For years, millions of Americans were told the same thing. If you want to carry a firearm in public, ask the government first. Fill out the forms, pay the fees, wait for approval. And then, maybe, if the right official feels like it, you get permission to exercise a right you were told already belongs to you. Now imagine waking up and finding out the highest court in the country just took a wrecking ball to that entire idea. That is exactly why this ruling matters. Because this was not just another court opinion buried in legal language. This was a direct challenge to the logic behind permit systems that gave government officials the power to decide who deserved to carry and who did not. But here's where it gets bigger than most people realize. This is not just about one state. This is about the future of carry rights across America. And what happens next may affect millions of people who have never even applied for a permit. If you care about gun laws, Supreme Court rulings, and what they actually mean in real life, subscribe right now. This channel breaks it down in plain English, without the noise, without the media spin, and right when it matters. Now let's talk about what just changed, and why the shockwaves are far from over. At the center of this entire fight was one question. Can the government force an ordinary, law-abiding citizen to prove some special need before carrying a firearm in public for self-defense? In New York, the answer had been yes. It wasn't enough to say, "I want to protect myself." Officials could demand more. They could decide your reason was not strong enough. They could say your need was too ordinary. And that is exactly what the Supreme Court rejected. In a 6-3 decision, the court struck down New York's proper cause requirement and held that ordinary, law-abiding citizens have a Second Amendment right to carry a handgun in public for self-defense. The court also said the Constitution does not let government officials require people to prove some unique need beyond normal self-defense before exercising that right. That is the part that hit like lightning. Because for decades, entire permit systems were built on the idea that the government could decide whether your reason for carrying was good enough. And the court essentially said, not like this. But that's only part of the story. This ruling exploded nationwide because it did more than strike one New York law. It changed the legal test courts are supposed to use in major Second Amendment cases. The court said gun restrictions should be judged based on the text of the Second Amendment and the nation's historical tradition of firearm regulation, not the balancing tests many lower courts had been using. That means lawmakers, state attorneys, and anti-gun advocates immediately understood something important. This was not a narrow paperwork dispute. This was a ruling with the potential to trigger challenge after challenge after challenge. Here's what most people are missing. The moment one major barrier falls, every similar law in other states starts looking vulnerable. Every pending case gets new momentum. Every state that relied on official discretion suddenly has to rethink how long that model can survive. That is why people said this ruling changed carry rights nationwide. Not because every permit vanished overnight, but because the legal foundation under discretionary permit systems took a direct hit. And the reality is far more significant than a lot of headlines made it sound. Now let's clear up the most dangerous misunderstanding. This ruling did not mean all permit systems in all 50 states instantly became unconstitutional. In fact, the opinion specifically said that many shall-issue systems, the ones using objective standards like background checks, fingerprints, and safety training, may still be permissible. That matters, because if you walk away from this thinking, no permits anywhere, no restrictions anywhere, carry whatever you want, wherever you want, you are walking into legal trouble. What this ruling directly attacked was official discretion. The idea that a government official can look at your application and decide your ordinary self-defense need is not enough. That is the target. Not every background check, not every training requirement, not every location restriction, not every licensing framework. But here's where things start getting complicated fast. Because once states lose one tool, they usually reach for another. This is where the next phase begins. Some states respond to rulings like this by backing down. Others respond by rewriting the same restriction in softer language and hoping the courts let it survive. That means you may start seeing new laws built around sensitive places, administrative rules, longer delays, higher fees, more paperwork, or other systems that technically do not say prove special need, but still make carrying harder in practice. And that is where future lawsuits come from. Because once the court says government cannot openly block a constitutional right through discretion, the next question becomes obvious. Can government still do basically the same thing through delay, cost, bureaucracy, or renamed restrictions? That question is going to shape the next several years of Second Amendment litigation. And if you think this only matters to people in New York or California, think again. Because what happens in one major ruling becomes the roadmap for the rest of the country. Let me make this real with 3 everyday scenarios. Scenario 1. You live in a former may-issue state. Before this ruling, your application could live or die based on whether officials thought your reason for carrying was special enough. Now that system is under direct constitutional pressure. The burden shifts away from you begging for approval and toward the state justifying its restrictions. Scenario 2. You already have a permit. A lot of people asked, does this make my current permit useless? Not necessarily. Your existing permit may still matter for reciprocity, for state compliance, or for interactions with law enforcement in places still operating under permit frameworks. Throwing it away just because the legal landscape shifted would be a mistake. Scenario 3. You travel across state lines. This is where many gun owners get blindsided. One ruling does not make every state law identical overnight. Some states will change quickly. Others will resist. Others will create new restrictions and dare someone to challenge them. So if you travel with a firearm, your risk doesn't come from what you think the ruling means. It comes from assuming every state now plays by the exact same rules. And that assumption could cost you. But wait, there's another layer almost nobody explains clearly. People myth number 1. This ended all gun permits nationwide. No. It was a major blow to discretionary, proper cause-style licensing, not a universal eraser for every permit system in America. Supreme Court opinion myth number 2. This means you can carry anywhere now. Also no. Sensitive place restrictions, private property rules, and other location-based limits did not vanish with this ruling. SCOTUS blog. Myth number 3. The fight is over. Not even close. The real fight often starts after the headline, when states rewrite laws, lower courts interpret them, and new cases start moving through the system. That is why the people who only watch the headline are usually the last to understand what the ruling actually did. This 6-3 ruling was a major turning point because it rejected the idea that ordinary Americans must prove a special need before carrying a firearm in public for self-defense. It hit one of the most powerful legal arguments used to ration carry rights through official discretion. SCOTUS blog. Supreme Court opinion. But the deeper story is this. The old system did not disappear cleanly. It cracked. And when a system cracks, the next battle is always about what rises in its place. That means your responsibility just went up. Know your state's current law. Know the states you travel through. Do not assume a viral headline is the same thing as legal reality. And do not confuse a huge constitutional win with the end of the fight. Because in the Second Amendment world, the first ruling is often just the opening shot. If this helped you understand what really changed, drop a comment with the state you live in and tell me whether you think your state will comply or try to work around it. And if you know someone who carries, send this to them. I'll see you in the next one.